Let's start. This revisional application is directed against the order number 50 dated 09/09/2010 passed by Learned Family Court Calcutta in matrimonial suit number 221 of 2003. Para. Respondent / husband filed a matrimonial suit number 221 of 2003 against the petitioner / wife praying for decree of divorce. Petitioner filed a petition under Section 24 of the Hindu Marriage Act praying for alimony for a sum of rupees 1 lakh for her monthly maintenance and rupees 1,50,000 for the maintenance of her mentally retarded daughter and rupees 50,000 towards litigation cost. Learned trial court by the impugned order rejected the prayer for alimony, parental right, and also for litigation cost. Para. Being aggrieved by and dissatisfied with the said order, the petitioner / wife has preferred this revisional application under Article 227 of the Constitution of India. Para. It is submitted by the learned advocate for the petitioner / wife that the petitioner / wife received a sum of rupees 1.60 crore from her husband / opposite party in terms of agreement for the purpose of purchasing a separate flat for her separate residence. She purchased the said flat at the cost of rupees 1.60 crore. The said amount of rupees 1.60 crore is not at all for her alimony / maintenance. Therefore, it is submitted that learned trial court was wrong in rejecting the prayer of maintenance and litigation cost. It is further submitted by the learned advocate for the petitioner / wife that Honorable Court in CO number 1324 of 2005 with CAN 5989 of 2006 has also held that the petitioner / wife shall purchase a flat for her separate accommodation out of the amount of rupees 1.60 crore, and therefore the order of learned trial court rejecting the prayer of rupees 1.60 crore, and therefore the order of learned trial court rejecting the prayer for alimony / maintenance on the ground of payment of rupees 1.60 crore as one-time settlement suffers from illegality and impropriety, and the said order should be set aside and necessary order may be passed for allowing alimony and litigation cost. Para. On the other hand, learned advocate for the OP / husband has submitted that agreement dated 16th June 2006 between the husband and wife reveals that the sum of rupees 1.60 crore was given as one-time settlement towards her future maintenance and separate accommodation, and wife shall not claim any amount of her maintenance in future. It is further submitted by the learned advocate appearing on behalf of the opposite party / husband that the opposite party has no further liability to pay any further amount towards maintenance in view of the payment of the said amount of rupees 1.60 crore as per terms of the agreement, and therefore learned court below was correct in rejecting the petition for alimony or the maintenance and litigation cost. Parachil. I have carefully heard the submission of both sides and perused the materials on record, including the impugned order passed by the learned court below from the deed of agreement dated 16th June 2006 made between the petitioner / wife and OP / husband. It appears that the agreement was made between the parties to the effect that the husband shall pay to the wife a sum of rupees 1 1.60 crore as one-time settlement towards her future maintenance and separate accommodation. The wife shall not claim any amount for her maintenance in future. From clause number 8 of the said deed, it appears that none of the parties shall have any claim against the other in future. From clause number 9, it further appears that the wife shall not bring any proceedings against her husband for her maintenance in any court of law. From clause number 7, it also appears that at the time of legal divorce or at any other time, no further claim will be made by the wife. Stop paragraph. On close and careful perusal of the terms of the deed of agreement, it is crystal clear that all kinds of claim of the wife, including maintenance, have been settled by the terms of said deed of agreement, wherein the husband is to pay a sum of rupees 1.60 crore as one-time settlement towards her future maintenance and separate accommodation, and the wife shall not make any claim in future at the time of divorce or at any other time, and wife shall not bring any proceeding against her husband for her maintenance. Attention of the court has been drawn to the order of this court in CO number 1324 of 2005 with CAN 5989 of 2006. This order was passed in connection with the terms of the agreement of the deed dated 6th June 2006. By virtue of the said order, this court adopted a method for implementation of terms of the deed of agreement. This court directed the wife to select a flat or a separate accommodation, and the cost of such flat or separate accommodation will be made out of the total amount of rupees 1.60 crore, which was agreed to be paid by the husband to the wife. This court in the said order made it clear that other terms of the agreement shall remain as it is bearer. On a close and careful perusal of the order of this court in the aforesaid CO, it does not at all appear that in terms of the deed of agreement, the husband agreed to pay the amount of rupees 1.60 crore only for purchase of the flat or separate accommodation. There is no whisper in the said order that the amount of rupees 1.60 crore does not include in maintenance or other claims, including litigation cost of the wife. On the other hand, this court in third paragraph of order in CO 1324 of 2005 with CAN 5989 of 2006 dated 1909-2006 held at the first instance after pursuing the terms of settlement. It appears to me that the petitioner was agreeable to pay a sum of rupees 1.60 crore to the respondent in full and final satisfaction of her entire claim towards future maintenance. If the parties have actually settled their disputes by paying one-time maintenance and disposing of all other cases filed against each other, I find no justification in keeping the matrimonial suit alive to be contested between the parties. Therefore, submission of learned advocate for the petitioner of the wife finds no merit in view of the order of this court in CO number mentioned above, as well as in terms of the deed of agreement dated 16th June 2006. Learned Trial Court in order number 50 dated 9th September 2010 in matrimonial suit number 221 of 2003 has rightly observed that pursuant to the agreement dated 16th June 2010, the wife received rupees 1.60 crore as one-time settlement towards future maintenance and separate accommodation. This court in CO number 1324 of 2005 by the order dated 11/09/2007 has also observed that it is not in dispute that the OP/wife in accordance with the said mutual agreement, has received an amount of rupees 1.60 crore towards alimony oblique maintenance for herself. It also seems to be the agreed position that the elder daughter of the parties is in the custody of the petitioner oblique husband, whereas the minor daughter, who is reportedly mentally challenged, is in the custody of the opposite party oblique wife. The opposite party oblique wife was left her matrimonial home along with the said minor child and is reportedly staying at Kanpur. The above position seems to be admitted para. After considering the order and observation of this court in CO number 1324 of 2005 together with CAN 5989 of 2006, that is order dated 1909-2006 and 1109-2007, I have no hesitation to hold that the wife of the petitioner received a sum of rupees 1.60 crore, not only towards her maintenance but also for all kinds of claim as one-time settlement for her future maintenance and accommodation. Therefore, in terms of the agreement, that wife of the petitioner is not entitled to claim any further amount for her maintenance in future. Attention of this court has also been drawn by the learned advocate of the petitioner of the wife to a letter dated 4th October 2006 to the effect that wife purchased the flat at a value of rupees 1.60 lakh. It is submitted by learned advocate for the OP oblique husband that petitioner oblique wife did not at all purchase any flat and she has been residing at Kanpur. No document towards the purchase of the flat by the said amount is furnished. Moreover, this court in CO number 1324 of 2005 has observed that wife has left her matrimonial home and is living at Kanpur with minor child, but this letter does not at all entitle the petitioner to claim any further maintenance in view of the complainants of the terms of agreement dated 16th June 2006 by OP oblique husband in the matter of payment of amount as well as in view of the observation of this court in the order dated 1109-2007 in CO number 1324 of 2005. In the facts and circumstances, I do not find any illegality or impropriety in the order number 50 dated 0909-2010 passed by learned court below. Therefore, divisional application stands dismissed without, however, any cost change. Photostat certified copy of the judgment and order, if applied for, be made over to the parties on usual terms. Stop there. This appeal is directed against the judgment and oblique or order dated 2nd June 2012 passed by the learned additional district judge 4th court at Nodia, Krishnanagar in matrimonial case number 923 of 2009 at the instance of the dependent oblique appellant. In connection with the said appeal, an application has been taken out by the dependent of the appellant praying for disposal of the appeal itself by directing the learned trial judge to dispose of the appellant's counter claim on merit in the light of the provision contained in order 7 Rule 6D of the Civil Procedure Code. Copy of the said application has been served upon the plaintiff oblique respondent. Affidavit of service has also been filed by the dependent oblique appellant. Let the said affidavit of service be kept with the record. Despite service of such a notice, the plaintiff oblique respondent remains unrepresented. Under such circumstances, the application filed by the appellant is taken up for consideration. Ex parte para. Here is the case where we find that the plaintiff oblique respondent wife filed a matrimonial suit against the dependent oblique appellant, within bracket husband, praying for dissolution of their marriage by way of decree of divorce. The appellant oblique dependent within bracket husband appeared in the said suit and filed a written statement containing counterclaim therein. In the said counterclaim, the husband also claimed a decree for divorce on different grounds. By the impugned judgment and decree, the suit for divorce filed by the plaintiff oblique respondent was dismissed for default on 2nd June 2012, as the plaintiff oblique respondent did neither take any step in her suit on the said date, nor she had shown any cause for her failure to take steps in the suit on the previous date of hearing, that is on 27th March 2012. The learned trial judge, however, refused to consider the appellant's counterclaim, as learned trial judge was of the view that the written statement filed by the appellant could not be regarded as a counterclaim of the appellant, as he claimed relief for divorce therein, which was identical to the prayer made by the wife in her suit. As such, no direction was given for consideration of the counterclaim of the defendant oblique appellant para. The legality and or propriety of the said judgment decree has been challenged by the defendant oblique appellant in this appeal para. We have considered the written statement filed by the defendant oblique appellant in the suit for divorce filed by the plaintiff oblique respondent para. On perusal of the said written statement, this court finds that the defendant oblique appellant filed the written statement containing counterclaim praying for divorce on the grounds as mentioned therein. Court fees in support of the relief claimed in the said counterclaim was also paid by him. Thus, after considering the written statement filed by the defendant oblique appellant as a whole, we are of the view that the said written statement contained counterclaim, and as such, in view of the provision contained in order Roman 7 Rule 6D of the Code of Civil Procedure, the counterclaim should have been considered independently even after dismissal of the plaintiff's suit for divorce for default para. Thus, this court holds that though the learned trial judge did not commit any mistake in dismissing the plaintiff's suit, as she neither appeared in the said suit on the date of hearing nor took any effective step for explaining the reasons for her default on the previous date of hearing, that is on 27th March 2012, but at the same time, the learned trial judge, in our view, committed illegality by not fixing a date of hearing of the counterclaim of the defendant or the appellant independently in the light of the provisions contained in order Roman 8 Rule 6D of the Civil Procedure Code para. Accordingly, the appeal as well as the application are disposed of with the direction upon the learned trial judge to register the counterclaim filed by the defendant or the appellant as an independent suit and dispose of the same on its merit in accordance with law para. Both the appeal and the application thus stand disposed of. Thank you. Jai Hind, Jai Mera Bharat.
Thank you.